the matter of Soteria Insurance Ltd and IBM UK Ltd.
Oh, very nice to see a full court.
My Lord, I'm here with Mr. Lazarus and Mr. Brune for the appellants, and we are outnumbered by Mr. Tozzi, Mr. Kramer, Mr. Levy and Mr. Munro for the respondents.
Yep.
Subject to the court's views, the parties have agreed a timetable for the next couple of days, with the time being split 50-50, assuming roughly 2 5-hour days, if that's acceptable to the court. To avoid fragmentation, all the issues are to be addressed together in opening, response and reply submissions. We will open today until 3:45. IBM will commence its submissions today from 3:45 through to tomorrow at 3:45, and then we will reply after that.
All right. That's
acceptable to the court.
Well, we were talking amongst ourselves before we started about how we might do it, and if that's what you've agreed, that's fine. Since it's obviously your appeal, you ought to have the last word, and I'm quite sure that the ground will have been sufficiently trampled on the respondent's notice for that not to be an issue. But technically, Mr. Tozzi, if there is anything after Mr. Thankey's finished on the respondent's notice points at 4:29 tomorrow, then you know, technically you can have a minute.
Well, my lord, I'm grateful. I'll try not to use it.
Fine. All right. Well, then that's fine, and that's very clear. So until 3:45. Right. Okay. Fire away.
My lords, I'll take the skeletons as read, so I don't propose to say anything more about the background to the dispute or the merits. We summarise our position on the overall merits in our supplemental skeleton at paragraphs 4 to 5 in core bundle tab 5, pages 66 to 68, but I don't propose to dwell on that for present purposes. In terms of the contractual structure, I would imagine the court is fairly familiar with this now, but there is the Master Services Agreement, or MSA, which is effectively a standardised set of terms governing the detailed services set out in the statements of work, or SALs as we refer to them. The MSA is at supplemental bundle tab 1, page 2. And obviously I'll come back to this in more detail shortly, including of course clause 23. The agreement, just for the court to note, perhaps we could just turn this up at page 59 in Schedule 1. The agreement is defined at the bottom of the page as clauses 1 to 46 set out in this document, i.e. the MSA, the schedules and appendices, and then you'll see in the third line the agreement is defined as including each SAL. As the court will have seen, there are 2 statements of work, both separately defined in Schedule 1. We don't need to turn that up. The implementation services SAL is at supplemental bundle tab 7, and again we don't need to dwell on this, just so the court knows where it is. At page 121, behind that tab, is where you find the reference to application gate 5, about 2/3 of the way down, which obviously the learned judge spent some time on the invoice arising under application delivery phase 5, and you'll see a figure of just under £2.9 million in the final column allocated to that.
Yeah.
The 10-year duration managed services SAL is at the following tab, and obviously I will need to come back to that in a little bit more detail, but I won't do so now. My lords, in terms of the structure of my submissions, there are on analysis 5 topics before the court, including the issues raised in the respondent's notice and in my client's response to the respondent's notice set out in the supplementary skeleton, there's quite a lot of ground to cover, so I hope the court will forgive me if I take matters at a reasonably fast pace. But logically, the topics arise in this order. The first issue and the key issue on our appeal is whether clause 23.3 of the MSA, which expressly includes liability for loss of profit, revenue and savings, also includes a claim for wasted expenditure. The second issue, if Sisgill succeeds on the construction of clause 23.3, should its appeal nevertheless be dismissed, as IBM says in its respondent's notice, because the judge was wrong to hold on the facts that Sisgill disputed IBM's AG5 invoice in good faith. That was the basis for her conclusion that when IBM purported to terminate the contract for non-payment of that invoice, it repudiated the contract. The third issue is raised by Sisgill's supplementary skeleton in response to the respondent's notice. If IBM succeeds on the second issue, i.e. that Sisgill didn't dispute the AG5 invoice in good faith, the question is, was IBM's purported termination nevertheless unlawful for a different reason, namely because Sisgill was entitled to and did raise a valid set-off before IBM purported to terminate, albeit after the expiry of the 7-day period for disputing invoices set out in the contract.
Mm-hmm.
And this issue is dealt with pursuant to the order of my Lord Justice Coulson in this way, pursuant to paragraph 1b of the Court of Appeal's order of the 1st of October, which is at Core Bundle tab 11. I don't need to take the court to that. The fourth issue, raised in IBM's respondent's notice, it is if in the light of the outcome of the first three issues, Sisgill is in principle entitled to recover its expenditure that was wasted by reason of IBM's repudiation of the contract, has IBM discharged the burden of showing that Sisgill would not have recouped its expenditure on the contract, even if IBM had not breached it, such that to award Sisgill compensation for any of its wasted expenditure would put it in a better position than if IBM had performed the contract. So that's the fourth issue. And the fifth issue, if the court is prepared to hear the issue, is the short point. If Sisgill is otherwise entitled to recover its wasted expenditure, that point concerns the applicable liability caps under 23.5 of the contract. That issue, my lords, has narrowed considerably even since our initial appeal skeleton was served, and it's now a very short and discrete point of construction.
And do you maintain the position that on that issue, this court has the kit to deal with it?
Yes, my lord. You have all the powers of the first instance court.
Well, I know we have the powers, but whether we have, as I say, the kit.
You do.
The necessary.
It really
material.
is a point of construction. There's no facts involved at all.
Right.
Simply a discrete point of construction interpreting the meaning of clause 23.5. I don't envisage it would take longer than 10 minutes of my time so to make the points in relation to that. And it's, in our submission, it's a far more economical way of dealing with it and remitting it back to the judge.
Well, the court would be anxious to deal with it if it can.
Yes, in our submission it can, and I don't see anything in the IBM skeleton which takes issue with that.
Okay.
I'm told if that's wrong. So, my lords, the first issue, the construction of clause 23.3. If we could then go, please, to the clause itself in the supplemental bundle, tab 1, in the Master Services Agreement, page 41. Where you'll find clause 23.3, and relevantly the court will see in line 4 that it excludes liability for claims for loss of profits, revenue and savings. Now, can I just say this, that those are the specific words that the judge relied on in concluding that claims for wasted expenditure were excluded by clause 23.3. And my learned friends accuse us of setting up a straw man by referring to profits in our skeleton. But the judge didn't confine her analysis to revenue and savings alone. So when I refer to profits, it is simply convenient shorthand for profits, revenue and savings. And if the court could keep a finger there in that page, the way the exclusion works is first of all to define losses very broadly. If one goes to Schedule 1 behind tab 2, at page 67, you can see in the middle of the page, losses are very broadly defined. And then we go back to page 41, 23.3. Then we see that the exclusion clause at 23.3 narrows it down to losses which are, in line 3, as set out below. And breaking it down, looking at clause 23.3, we can see that it expressly excludes liability for all indirect or consequential damages, even if losses were foreseeable, and even if a party had been advised of the possibility that such losses were in the contemplation of the other party or any third party, and whether damages arise in contract, tort, including negligence, breach of statutory duty or otherwise. So very broad. And then one can see from the clause that 6 additional categories of loss, whether direct or indirect, were expressly excluded, namely 3 types of commonly claimed financial damages, being loss of profits, revenue and savings including anticipated savings. And then secondly, 3 much less commonly claimed types of loss were also expressly excluded, namely loss of data, goodwill and reputation. And our starting point is that we make the obvious point that despite the comprehensive types of loss mentioned, there is no express reference to wasted expenditure. Unlike many clauses in commercial contracts, and we give some examples, footnote 3 in our skeleton. And with that background, the short version of our argument is therefore this. The claim for wasted expenditure is exactly that. It is not a claim for lost profits, revenue and savings. The language used by the courts, contracting parties and academics consistently draws a distinction between claims for wasted expenditure and claims for loss of profits, revenue and savings. Although all claims for loss of bargain are governed by the compensatory principle, a claim for wasted expenditure is for actual incurred costs. A claim for loss of profits, revenue and savings is a claim for unrealised benefits. The fact that both types of claims are governed by the compensatory principle cannot, as a matter of construction, mean that a claim for loss of profits, revenue and savings is taken to mean a claim for wasted expenditure on its natural and ordinary meaning. And the effect of the judge's conclusion is very stark. The judge found that my clients wasted £122.6 million in reliance on the contract. That's, to give you the reference, the judgment below paragraph 704 to 727. And that wasted expenditure, my lords, included...
Sorry, what was the reference again?
704 to 727.
Thank you.
So ladyship's conclusion on that wasted cost. And that wasted expenditure included £34.1 million in payments to IBM. The reference to that is the judgment at paragraph 714. all of which she held to be irrecoverable. And whether that was really the intended outcome requires, in our submission, very careful scrutiny of clause 23.3. My Lords, this was a professionally drafted clause with language that was in parts, as you can see, repetitive or superfluous, particularly in the second half of the clause. It is unlikely in our submission that the drafters would not have excluded wasted expenditure expressly if that was what was intended, especially when such claims were highly foreseeable. Now, IBM seeks to suggest that this point is a straw man in the skeleton at paragraphs 26 to 27 by saying that one can always say the drafters could have made it clearer when you don't like a particular construction of the contract. But in our submission, it is emphatically not a straw man. It's a critical point of construction. This includes not just looking at the ordinary and natural meaning of loss of profits, revenue, and savings, and the distinction between such losses and wasted expenditure as conventionally understood. Critically engages the principle that clear words are needed to exclude valuable common law rights. And I'll come back to that if I may. And interpretation also involves evaluating the nature of the clause against the commercial background. And as I said, claims for wasted expenditure were highly foreseeable, particularly in this type of contract. Arguably, much more foreseeable than, for example, loss of reputation, which is also expressly included in the, or rather excluded in 23.3 in express terms.
Thank you. Can I just understand
Yes.
a moment? You're referring to loss of profit, revenue, savings, etc. And my understanding, you're referring to those as though those are core loss of bargain damages, but I don't think it doesn't seem right to me. The primary loss of bargain in a contract claim is the cost of obtaining the same services.
Yes, that was the point I was about to come on to. So what it is common ground that the costs of reprocurement are not excluded. And
all of these items are really broadly within the concept of consequential losses, aren't they?
yes,
And this is a clause which says you can have damages for our breach, but you can't have the fact that if we had performed, you would then have made lots of profits. And it's an understandable exclusion because
yes,
plainly a business that's deprived of a computer system may lose lots of revenue and profits for years into the future.
in a very difficult, in an open-ended, possibly,
Yes.
and difficult to quantify way. Yes.
But the basic concept of, well, we're entitled to how much we've lost because it costs us so much more to get these services elsewhere. I don't see any difficulty in wasted expenditure being an alternative to that.
Indeed, and that's indeed your lordship preempted the point I was about to move on to, which is that this does flow from the fact that it's common ground between the parties that reprocurement costs are also not caught by the exclusion in 23.3. And consideration of that assists in analysing the parties' intentions and the proper construction of the clause. Because those types of reprocurement costs that my Lord mentions are paradigm claims for loss of bargain, because an award of damages equal to the additional cost of implementing a substitute system is intended to place the purchaser into the same position as if the contract had been performed.
But that would include, wouldn't it, some elements? There's an overlap because that would include the sums that you have paid to IBM for nothing.
Indeed.
And so you would get those sums, it seems to me, on either basis.
Yes. Certainly some of them. Not necessarily all of them. And there are other sums involved in the judge's analysis, which includes, for example, the cost of financing, etc.
Yes.
Which are more complicated.
Yes.
But even on the logic of the judge's approach, claims for reprocurement costs are obviously not excluded by 23.3 because they are not claims for loss of profit, revenue, or savings. So clause 23.3 therefore expressly excludes some, but not all types of loss of bargain damages. And there's nothing surprising about that commercially. Parties may be willing to permit claims for wasted expenditure or reprocurement costs, but not claims for loss of profit, revenue or savings, because like claims for wasted expenditure, claims for reprocurement costs are inherently capped, namely at the actual additional costs of implementing a substitute system. And they're also easier to quantify and verify than loss of profits, revenue or savings. And we submit that is a perfectly coherent scheme to exclude three types of loss of bargain damages, namely profit, revenue and savings, which have no inherent caps and which are harder to quantify and verify, but not two other types, namely wasted expenditure and reprocurement costs, which are inherently capped and which are easier, much easier to quantify and to verify. And again, in this context, in our submission, this strikes a fair balance between the parties and is inherently likely to be what the parties intended. I'm going to take the court in due course to an article by Professor Peel, which draws the distinction between a clause, sees this clause as the type of clause where the party is not compensated for not being made better off, but is compensated for being made worse off, as it were, by the contract, by the breach. And it's a perfectly coherent way of looking at the balance between what is excluded and what isn't excluded in this clause. Now, with that, if we could turn to the judgment, put away the supplemental bundle and go to the core bundle, and the judgment of Mrs. Justice Zacaroli is behind tab 7. And looking at the judgment, it is a notable feature of this case that the judge directed herself impeccably on the correct test for construction. And if we go to paragraph 266 at page 148, one can see she cites the trilogy of cases from the Supreme Court of Arnold and Britton, Rainy Sky and Chartbrook. She could have mentioned Wood and Capita, but it makes no difference for present purposes. And you'll see that she talks about there being no dispute about the questions of contractual interpretation. And her ladyship says that when interpreting a written contract, the court is concerned to ascertain the intention of the parties by reference to what a reasonable person having all the background knowledge which would have been available to the parties would have understood them to be using the language in the contract. And then she talks about focusing on the meaning of the relevant words in their documentary, factual and commercial context. Meaning has to be ascertained in the light of, one, the natural and ordinary meaning of the clause, and that's the primary approach to construction. Secondly, other provisions of the contract. 3, the overall purpose. 4, the facts and circumstances known or assumed by the parties at the time the document was executed. And 5, commercial common sense, but disregarding subjective evidence of intentions. And we have no criticisms of that direction to herself made in another context, in the contract, in the judgment. But in our submission, when she came to analyse clause 23.3, the judge, with great respect, lost sight of the correct approach. In short, our criticism is that there is simply no attempt to ascertain the objective meaning of the language that the parties have chosen by reference to what a reasonable person possessing all the background knowledge of the parties would have understood the contractual language to mean. And if we go on, the judge dealt with wasted expenditure at paragraph 666 onwards, beginning at page 239 of the bundle. and you'll see she sets out at 666 the clause, the definition of losses at 667, the parties' rival contentions, and then paragraphs 670 through to 679, her ladyship set out the principles established by the cases, and she summarises those at page 679, paragraph 679 on page 244. And in the third line, she says a claim for wasted costs can be explained as compensation for the loss of the bargain based on a rebuttable presumption that the value of the contractual benefit must be at least equal to the amount that the claimant is prepared to expend in order to obtain such benefit. And we don't quarrel with that summary. And we will come back to the Atos case that her ladyship mentions in that paragraph a little later. If we go back to page 240, we just see the structure of her analysis. And at paragraph 670, she mentions the well-known compensatory principle based on the Robinson and Harman case, Baron Park's decision. And then at 671 to 672, she cites Supreme Court cases underlining that in all cases, the aim of damages is to put the victim in the position that he would have been in if the contract had been performed. 673, her ladyship describes the expectation basis of damages, usually framed in terms of loss of profits, etc. And she cites OMAC, which we'll come back to, the decision of Mr. Justice Tier in OMAC. And then at paragraph 674, she describes the alternative reliance basis, usually being wasted expenditure, and we will come back to the Anglia TV case in a little while. And at 675, her ladyship explains the limits of the reliance basis, i.e. there is no entitlement to recover expenditure if the expenditure would have been wasted in any event, and you'll see she refers to the CMP haulage case. Paragraph 676, she mentions that the burden is on the defendant to show that the expenditure would have been wasted because of a bad bargain. And I'll come back to that issue in the context of the Yan Seng decision of Mr. Justice Leggett, as he then was. And in short, the court will have seen our submission is that IBM never discharged that burden, and that raises issues addressed under the fourth issue identified at the outset. And then at paragraph 677, this is getting into the meat of the judge's core reasoning. The judge correctly says, you can see from the beginning, that reliance losses involve a different method of measurement, but ultimately still provide compensation for loss of bargain. And the judge refers to the OMAC case there to show that expectation losses and reliance losses, you see this at the top of page 243, that expectation losses and reliance losses have the same juridical basis. And why all this matters is to avoid compensation for expenditure which would have been wasted in any event, applying the basic compensatory principle. And reliance damages are therefore still subject to the compensatory principle, and that's confirmed by the Yan Seng case, which she cites, the court will see from paragraph 678. And then we've looked at 679, and then really paragraph 680 through to 686 is where the judge very briefly sets out her conclusion on the effect of clause 23.3. Paragraph 680, you'll see what she describes as the starting point to identify the contractual benefit lost. In our submission, the starting point is to construe the clause by applying the principles summarised by her ladyship in paragraph 266. That ought to be the first port of call. 681, she refers to Siskel's business and an aim to produce substantial savings, increase revenues and increase profits. In our submission, that we don't quarrel with that, but in our submission, the loss of bargain was also not obtaining the system that IBM had contracted to provide, and the 10 years of managed services, as well as the implementation of the system itself.
Well, that's the primary loss of bargain.
Yes.
Because the theory is that you can replicate what you would have had from the contract by going and getting somebody else to do it, and then you won't suffer the loss of savings, revenues, and profits. So those are not the loss of bargain principle. Those are consequential matters which should be capable of being mitigated by damages for loss of bargain.
Yes, if one really has to get to the nub of what the loss of bargain is, it is not getting the system that you contracted for and the services we contracted for over a 10-year period. That is the true loss of bargain, as your Lordship says, that those are the consequentials of the knock-on effect of the loss of the primary bargain. And your Lordship touches on a point which Professor Peel raises when he says that the distinction that her ladyship draws between her own decision in the Atos case and this case doesn't make sense, because the loss of bargain is not getting the basic thing that you contracted for. In this case, the system and the services.
Well, the judge seems to have worked on the assumption that savings, revenues, profits encapsulated here loss of bargain.
Yeah, which is looking at the commercial reason why.
That seems to be quite a fundamental error.
In my submission, that's correct. And there are two errors we've identified so far. One is failing to construe the actual meaning of the clause, and the second is identifying the loss of bargain. We don't quibble with her point as to what the consequential effect would have been of the loss of bargain, but the primary loss of bargain is not getting the system we contracted.
Well, she's sort of short-circuited the... Having referred to all the authorities, she's really short-circuited and said, well, what I've got to look at is what is the contractual benefit lost, and if that's excluded, then wasted expenditure is also excluded because it's equivalent, and that seems to me is all wrong.
It's a jump in reasoning which isn't justified. As your Lordship says, it is a short circuit, and there's a degree of reverse engineering from identifying that loss of bargain to jump back into the clause. And then at 683 to 686, it's necessary to try and unpick what the ladyship is saying there. She talks about a conventional claim for damages being framed in terms of lost savings, revenues and profit. She says Siskel is entitled to frame its claim as one for wasted expenditure, but that simply represented a different method of quantifying the loss of bargain. It doesn't change the characteristics of the losses for which compensation was sought. And then 23.3 of the MSA excludes any claim by either party for loss of profit, revenue savings, etc., in all cases whether direct or indirect. And then 685, in accordance with the above analysis, such a claim is excluded whether it's quantified as the value of the lost profit, revenue and savings, or as wasted expenditure. And then she concludes it follows that Siskel's claim for wasted expenditure is excluded by clause 23.3. But just unpicking that, any valid damages claim at common law would be to compensate for the loss of bargain occasioned by the breach. And this of itself doesn't answer the issue of construction which arose in this case. Identifying the common juridical basis of a claim for loss of profits and a claim for wasted expenditure is no substitute for asking whether a reasonable person with the same background knowledge as the parties would have understood clause 23.3 to exclude wasted expenditure. And with respect, the judge's approach is flawed and is tantamount to saying that apples must be taken to mean oranges because they both belong to the family of fruit. And it's an impermissible jump. So far as we are aware, my lords, no other judge has suggested that a claim for wasted expenditure is to be interpreted as a matter of construction as a claim for lost profits, revenue or savings. In fact, the courts have consistently proceeded on the basis that wasted expenditure claims and claims for loss of profits and revenue are distinct, albeit governed by the overarching compensatory principle. And our criticism of this judgment is that there is no conventional construction exercise undertaken by the judge. Rather, the judge's conclusion appears to be that clause 23.3 excludes wasted expenditure ipso facto, without more, seemingly as a matter of law. And it comes across more as a deeming exercise than a proper exercise of construction. And really it seems to be based on legal theory rather than standing back and looking at what the parties intended to be excluded. Now, IBM scarcely seeks to defend the judgment as a matter of construction, and there are really only 2 points they make which can be said to be truly matters of construction rather than legal theory. If we go to IBM's first skeleton in the same core bundle behind tab 4, paragraph 21 at page 49.
Thank you. Mention I'm working electronically.
Oh.
So until you say the page number, I can't move.
I'll try and remember to start with the page number first.
It's helpful if you can.
Certainly. So page 49, paragraph 21. And what is said there by IBM is that clause 23.3 is clear, that neither party should be liable to the other for loss of profit, revenue, savings. And they say at the end those clear words should be given their natural and ordinary meaning. My lords, they are indeed clear words, but we would ask in what linguistic universe can the natural and ordinary meaning of wasted expenditure be taken to mean the same thing as loss of profits, revenue and savings? Wasted expenditure and loss of profits or revenue do not mean the same thing, and the judge recognised that they involve different measures of loss, as we saw at paragraph 677. And so they do. A claim for loss of profits, as I say, or revenue includes a projection of unrealised benefits. Wasted expenditure claims must involve proof of a sustained detriment. The linkage between wasted expenditure and loss of revenue or profits is not that they mean the same thing. Rather, the linkage between them is that the juridical basis for recovery involves a rebuttable presumption that the wasted expenditure would have been recouped from the expected benefits if the contract had been performed in accordance with its terms.
Sorry, a rebuttable presumption that
the wasted expenditure would have been recouped from the expected benefits if the contract had been performed in accordance with its terms.
Yeah.
And it is that linkage which reconciles the recovery of wasted expenditure to the overarching Robertson and Harman principle. But it is no more than an assumption. It emphatically does not mean that wasted expenditure and loss of profits, etc., are the same thing when it comes to the construction of clause 23.3. Now, the only other attempt by IBM to reconcile the judgment to any conventional construction exercise is in the same skeleton, page 51, paragraph 28, second line, contract between sophisticated and legally advised parties such as the parties to this litigation is to be construed on the basis that those parties know established principles of law. And then at footnote 35, there's a reference to triple point technology and Lady Arden saying that parties must be taken to know the general law. But with respect, where does that take us? Knowledge of the general law means that the parties can at least be taken to have known that wasted expenditure involves a different measure of loss to types of loss expressly provided for in terms in clause 23.3. The common juridical basis of the conventional claim for loss of profits, etc., and wasted expenditure, identified by the judge at paragraph 683, essentially goes to the overarching constraints imposed by the compensatory principle. That's primarily focused on avoiding overcompensation, whatever type of loss you claim. But that is a matter for the law of damages at large, not something which assists in the proper construction of the clause. And to identify, as the judge did at paragraph 677, that reliance losses and expectation losses are both forms of compensation for the loss of bargain, cannot of itself determine the construction of the clause and what the parties intended to exclude. Now, it is possible to see a more conventional approach to construction in the judgment of Mrs. Justice Mulder in the motor track case, and it may be useful just to look at that briefly. It's in Authorities Bundle 2. My Lord Justice Phillips, it begins at page 381 in the Authorities
Thank you.
Bundle. It's Authorities Bundle 2, tab 14. It's a decision in a case called Motor Track and FCA Australia. And we don't need to go into facts in any detail. The dispute concerned a contract for supply of web-based marketing services by Motor Track to FCAA. And if we go, please, to paragraph 82, page 405. At the end of paragraph 82, you can see that Her Ladyship held that FCAA was in repudiatory breach of the agreement. And then paragraph 83, you can see Motor Track's claims, and the relevant claim for present purposes is in Little Roman 2, damages for loss of profits.
There's a slight problem in that the page numbering doesn't match. Not uncommon.
Does your Lordship have that on page 405?
I can see it's 405 in the electronic bundle. It's 407.
Ah.
Never mind. I'll manage.
Okay. I'll try and give the paragraph
yes.
numbers. So if we could go on. If we could go on to paragraph 95, might be 410 in.
Yes,
At paragraph 95, one can see that it's FCAA's case that the claim is excluded by reason of clause 9.52 of the original agreement, which excludes liability for loss of profit. And you can see clause 9.5 set out in 96. Neither party shall be liable to the other for any indirect or consequential loss or damage at all, or any loss of business, capital, profit, anticipated saving, reputation or goodwill arising out of or in connection with the agreement or its subject matter. So one can see that the exclusion clause, in terms of its heads covered, is materially in similar terms to 23.3. And then if we go on, please, to paragraph 111, just ask the court to note that the Ladyship directs herself correctly in line with the Supreme Court decision in Wood and Capita. See that from 111, and going back to paragraph 92, she cites Lord Hodge's judgment in a couple of places. And then the conclusion, we find at paragraph 131 that she found that Motor Track's claim for loss of profit arising out of the failure by FCAA was excluded by clause 9.5. And then 129, if we go back a page, this. In this case, while it can be said that FCCA's construction will leave Motortrack without a claim for lost profits for FCAA's repudiation of the contract, there's nothing in the language which would support Motortrack's interpretation. The dicta of Mr. Justice Flo above, in my view, are limited to the situation where another construction is possible on a literal reading of the clause. In my view, this is not such a case. Further, although Motortrack on the defendant's construction would be left without a claim for loss of profits, the clause does not preclude a claim for wasted costs arising out of the repudiation of the contract. The feature of Motortrack's business that the revenue to be earned from this particular contract was largely, if not wholly, profits. There's no evidence this was part of the factual matrix against which this agreement was concluded. Accordingly, adopting the approach of Mrs. Justice Carr and Fujitsu, it cannot be said that FCAA's construction would deprive the contract of all contractual force. And you'll see she had referred earlier to the kudos decision of the Court of Appeal. And she makes the same point on wasted expenditure back at paragraph 108, where she says FCCA's construction with the exclusion clause Motortrack would have no remedy in the circumstance for the refusal of FCA to perform, other than a claim for wasted costs. Now, IBM responds to our reference to Motortrack by saying that the judge's conclusion that clause 9.5 did not exclude wasted expenditure was reached without analysis and consideration of the authorities identified by the judge below in our case, because there was no claim in Motortrack for wasted expenditure. But in our submission, that misses our essential point that we seek to derive from this case. We rely on the decision as a helpful indication of what meaning is to be given to the words by a conventional construction based on the application of the reasonable person test, applying cases like Wood and Capita. The hypothetical reasonable person reaches a conclusion as a matter of the natural and ordinary meaning of the words used, the purpose of the clause, applying commercial common sense, and all, in our submission, without needing the benefit of leading counsel at their shoulder armed with a bundle of authorities. And contracts are supposed to serve the purposes of business people. And to see where the judge below has gone wrong, it is very useful to look at the decision of the same judge in the Royal Devon and Atos case, because those two cases should be viewed together in reflecting the same approach to construction. This is instructive. And we can pick that decision up in Authorities Bundle 3, page tab 19.
I was pleased to see this because I remember this case. And I think I ordered the preliminary issue, and I never knew what the answer was. And it was only in reading for today's case that I have been supplied with that some 4 or 5 years after the event.
Indeed, yes. The judgment records that you ordered your lordship ordered the preliminary issue.
And at least it doesn't criticise me for ordering it, which is not uncommon. But,
the only thing I'd say by word of warning is it doesn't give you the complete end of the story, because there was a successful appeal from the second half of her ladyship's judgment, which doesn't arise. There was no appeal from the first half. But she was overturned on issue 2, which I'll show you in a moment. So looking at the Atos case, in the head note, you'll see the Royal Devon and Exeter NHS Foundation Trust, an NHS trust responsible, amongst other things, for the Royal Devon and Exeter Hospital. In 2011, it wished to obtain electronic document management and associated IT services, and therefore entered into a contract with the defendant, Atos, an IT provider. And then we can skip down to the following paragraph. In November 2014, the Trust served a contractual notice of material breach in respect of the alleged failure by Atos to remedy defects in the system. And on 21st of April, the Trust served a notice on Atos terminating Atos's services under the contract, accepting what was said to be a repudiatory breach by Atos. The Trust issued proceedings against Atos seeking damages in the sum of approximately £7.9 million for breach of contract. And then we can see the relevant exclusion clause, the next page, left-hand column, clause 8.1.3, four lines down, contain an exclusion of liability provision in the following terms. Without prejudice to the generality of subclause 8.1.1, neither party shall be liable to the other for loss of profits, or of business, or of revenue, or of goodwill, or of anticipated savings, and or indirect or consequential loss or damage. And you'll see from 1 that it's in very similar terms in terms of its heads of coverage as the exclusion clause in the present case. And then issue 1 is identified at the foot of that left-hand column. Damages claimed by the Trust included wasted expenditure. Atos argued that these damages were excluded from recovery by reason of terms in the contract excluded either expressly or impliedly lost profits, business anticipated savings, or indirect or consequential loss or damages. And then issue 2, one can see identified just at the top of the following column, issue 2 related to the liability cap in the contract, which needn't concern us for present purposes. And if we go on, please, to where her ladyship deals with issue 1, paragraph 48, it's page 535 in my bundle. See just above paragraph 48, the heading issue 1. Don't think we need to spend much time on the submissions which cover familiar ground. Mr. Charlton was in both our case below and in this case. And the legal principles in the right-hand column will appear as quite familiar to the court because it's pretty much the same schema as in the judgment below. She talks about Robinson and Harman in paragraph 53. One of the two Supreme Court cases is mentioned in 54 in identifying the compensatory principle. The expectation basis of damages is explained in 55, reliance basis in 56, refers to OMAC and Yam Seng in 57, and then at 58 she says a claim for wasted costs can be explained as compensation for the loss of bargain based on a rebuttable presumption that the value of the contractual benefit must be at least equal to the amount that the claimant is prepared to expend in order to obtain such benefit. That presumption applies equally to cases of non-pecuniary benefit, where the claimant does not expect or aim to make profit. And then 59, the trust case, we can skip down, is that it's entitled to recover, 4 lines from the end, to recover the wasted expenditure as damages for breach of contract, based on a rebuttable presumption that the value of a functional EMR system would be at least equal to such expenditure. At 60, the trust is not entitled to recover as damages any lost profits, nor any lost revenue or savings. However, at 61, that does not preclude the trust from recovering damages to compensate for the loss of a functioning EMR system. That was a contractual benefit to which the trust was entitled, and of which it has been deprived by Atos's alleged breach. Just picking up on the point raised by my Lord Justice Phillips, it's very curious that she identifies the contractual benefit differently in Atos and in our submission correctly at this point compared to her judgment below. The rebuttable presumption that the value of that loss is at least equal to the trust's expenditure does not transform the claim for loss of the EMR system into a claim for loss of any additional benefits that would flow from use of the EMR system. 62. Atos's submissions wrongly assume that any contractual benefit which is presumed to at least equal the value of the expenditure must represent profits, revenue or savings. In most commercial cases there would be such a defined financial benefit that would be expected to defray the costs incurred and render the bargain financially viable. However, this is not the case where the contractual benefit is non-pecuniary. In those cases, the anticipated benefit is not a financial gain that could defray the costs incurred, but rather a non-pecuniary benefit, which the claimant is prepared to incur such costs. In cases where a party does not expect to make a financial gain, it is the non-pecuniary benefit that is assigned a notional value equivalent to at least the amount of expenditure. In this case, regardless whether the EML system was anticipated to produce any profits, revenue or savings, the trust would have the use of the EML system as a contractual benefit. The claim for wasted expenditure is based on a rebuttable presumption, not that the EML system would produce revenues to defray such expenditure, but rather that the use of the EML system was worth at least the expenditure incurred. And then at 65, that it's open to Atos to defeat the claim for wasted expenditure by establishing the expenditure exceeded any benefit to be gained from the contract. And 67, as if the defendant can establish that the claimant's expenditure would have been wasted in any event because it made a bad bargain, that the wasted expenditure will not be recoverable as damages, referring to OMAC and saying. And then 68, the burden of proof lies on the defendant to show the expenditure would not have been recouped and would have been wasted in any event. And then at 69, she says the bad bargain principle does not change the characterisation of the damages claimed from compensation for loss of a functional EMR system in compensation for lost profit, revenue, savings. And then her conclusion at paragraph 70 that the trust claims for breach of contract by reference to wasted expenditure were not excluded by clause 8.1.3a of the contract. Now, in our respectful submission, this is an odd approach to construction. Would the hypothetical reasonable person really have regard to whether the anticipated benefits of the contract were to be properly characterised as pecuniary or non-pecuniary before concluding whether the meaning of the words in the exclusion clause applied to exclude wasted expenditure? On this analysis, two identical clauses in two identical contracts would stand to be interpreted differently, depending on whether the claimant's intended benefit from the contract could be sufficiently expressed in non-pecuniary terms. With respect, if Atos is correct, it suggests that something has gone badly wrong with English law. Contracts, as I said, are supposed to serve the practical needs of business people. That type of analysis is simply not something which would be expected before construing the ordinary meaning of words in a contract. And we would add that no previous case has seen fit to differentiate between pecuniary and non-pecuniary benefits in the way the judge did in Atos as part of its ratio. And it may be useful just in the context, in this context, just to look at Lord Steyn and well-known Manai decision in Authorities Bundle 2, tab 13. The reference I have for it is A346, thereabouts. Behind tab 13 in Authorities Bundle 2.
Sorry, you said the page.
I haven't yet. It's page 368 in the bundle. In the internal law report, it's 771. And in the top of between letters A and B, just after the quote, Lord Steyn says, in determining the meaning of the language of a commercial contract and unilateral contractual notices, the law therefore generally favours a commercially sensible construction. The reason for this approach is that a commercial construction is more likely to give effect to the intention of the parties. Words are therefore interpreted in a way in which a reasonable commercial person would construe them, and the standard of the reasonable commercial person is hostile to technical interpretations and undue emphasis on the niceties of language. And we would venture to suggest that the judge's distinction between pecuniary and non-pecuniary benefits would have struck Lord Denning as an irrelevant question. And with that, can we look at Anglia TV and Reed, Authorities Bundle 1, Tab 2.
One of the difficulties, speaking for myself, that I have with that is that all benefits are that there is always some non-pecuniary benefit in a contract. And even the most thrusting FT 100 company who does things pretty much solely for profit, if they are, for example, investing in a new IT system with all its bells and whistles, part of the reason for that is because of the benefits that that has and is seen to have in terms of their staff. Now, that's a non-pecuniary benefit, but it is one of the things that certainly people often say is a benefit from having a modern computer system.
Yes, and it goes deeper than that. In this case, the judge herself, at paragraph 37 of the judgment, identified a particular and very important non-pecuniary benefit in the form of regulatory compliance, because one of the problems with our creaking old system was actually achieving various requirements of the PRA in terms of regulatory compliance. And at paragraph 37, her ladyship identifies that PRA compliance with the PRA's requirements is one of the benefits which is intended from this particular contract. And if one looks at the MSA in clause 2, one can see a number of benefits specifically identified in the contract. And it's very difficult to pick through them and say, well, these are pecuniary and these are non-pecuniary. And it actually shows the difficulty of applying the judge's testing methods if one is expected to pick through a contract and say, is this sufficiently non-pecuniary? It's almost impossible, and which is why ultimately one focuses on what the bargain was. What did you contract for? Rather than trying to salami slice between benefits being pecuniary or non-pecuniary.
Sorry, I took you off course. You were showing us...
Yes, Anglia TV and Reed. It's Authorities Bundle 1 behind tab 2. And I thought I had the electronic bundle references, but it's A10 page. I'm just looking at it's a very well-known case, but just looking at the head note, just to remind the court, case concerned the defendant, a well-known actor, contracting with the plaintiffs to play the leading man's part in a television play, which they were producing. A few days afterwards, the defendant repudiated the contract. Plaintiffs could not get a substitute for the defendant and accept his repudiation. They abandoned the production. The plaintiffs sued the defendant for damages. They claimed their total wasted expenditure of £2,750. And then we go on to page 13, Law Report, page 63. Below letter D, Anglia TV. Anglia TV then sued Mr. Reed for damages. He did not dispute his liability, but a question arises of damages. Anglia TV do not claim their profit. They cannot say what their profit would have been on this contract if Mr. Reed had come here and performed it. So instead of claim for loss of profits, they claim for wasted expenditure. And then if we go to the foot of that page, it seems to me that a plaintiff in such a case as this has an election. He can either claim for loss of profits or for his wasted expenditure, but he must elect between them. He cannot claim both. If he has not suffered any loss of profits, or if he cannot prove what his profits would have been, he can claim in the alternative the expenditure which has been thrown away, that is, wasted by reason of the breach. And you can see those basic principles in Anglia TV being applied by Mr. Justice Leggett, as he then was, in the Yamseng case, and it is useful just to spend a little bit of time on that. Probably the most up-to-date, comprehensive recitation of the position. And it's Authorities Bundle 3, tab 23. The reference I have for it is 648, Authority 646. And just looking at, if the court is there, just looking at the head note, see that Yamseng was a company operated by T from Hong Kong. ITC is a company based in the UK, operated by P, approached Yamseng with a proposal that they enter into an agreement for the distribution of deodorant and other toiletries, which were branded to show an association with Manchester United. A basic contract setting out the agreement was concluded, which inter alia granted to Yamseng exclusive rights to distribute, market and sell products, including deodorants and toiletries, specified the duty-free retail price and Yamseng's buying price for 6 products, and specified a territory within which Yamseng was to distribute the products. Those are the basic facts, and then if we go on to the holdings, at page 648, internal 1323, at letter E, one can see that Mr. Justice Leggett holds that ITC was in breach of the agreement. The breach was a repudiation and justified Yamseng in terminating the agreement, and accordingly judgment would be given for Yamseng. And then, holding 2, there was a rebuttable presumption that the claimant would have recouped expenditure incurred in reliance on the defendant's performance of the contract, which is an illustration of an approach whereby the court would attempt, so far as it reasonably could, to assess the claimant's loss, even where precise calculation was impossible, aided by making reasonable assumptions. The advantage of claiming damages on the reliance basis was not that the claimant would recover expenditure which would have been wasted even if the contract had been performed, but that where such a claim was made, the burden of proof lay on the defendant to show the expenditure would not have been recouped and would have been wasted in any event. In the instant case, ITC had not attempted to discharge the burden of showing what financial return would have been made if ITC had not been in breach of the contract. While it's reasonable to suppose that YS would have made more sales than it in fact had, it was impossible to determine whether any additional proceeds would have been sufficient to defray YS's expenditure. Moreover, ITC had not put forward any estimate of what loss, if any, YS would have suffered in those circumstances. Accordingly, YS is entitled to recover as damages for ITC's breach of contract its net expenditure incurred in performing the agreement. And with that, we could go on, please, to page internal 1360, A685, paragraph 185. And at 685, you'll see that Mr. Justice Leggett concludes that Yamseng has failed to prove what profit it would have made, or indeed that it would have made profit at all if ITC had fully performed its obligations under the agreement. And in holding it was entitled to claim wasted expenditure, one can see a classic application of Anglia TV and Reed, as we looked at it a moment ago, notwithstanding that inability to prove any loss of profit. And under the heading Claim for Wasted Expenditure, ITC's alternative claim is for its net expenditure incurred as a result of entering into the agreement. You'll see he cites and complements the OMAC decision of Mr. Justice Tier and says that the judge had shown that awarding compensation for wasted expenditure is not an exception to the fundamental principle stated by Baron Park in Robinson, i.e. that the aim of an award of damages for breach of contract is to put the injured parties, so far as money can do it, in the same position, etc. Method of giving effect the same fundamental principle. And then we can pick it up at 187. The advantage of claiming damages on the reliance basis is not that the claimant can recover expenditure which would have been wasted even if the contract had been performed, but that where such a claim is made, the burden of proof lies on the defendant to show that the expenditure would not have been recouped and would have been wasted in any event. And he cites from CCC Films and the decision of the US Supreme Court in Albert and Armstrong Rubber, and just below H, where Chief Justice Learned Hand says it's often very hard to learn what the value of the performance would have been. It's a common expedient, and a just one in such situations, to put the peril of the answer upon that party who by his wrong has made the issue relevant to the rights of the other. And then at 188, the common expedient referred to by Chief Justice Learned Hand reflects a general theme which runs through the law of damages. On the one hand, the general rule that the burden lies on the claimant to prove its case applies to proof of loss just as it does to the other elements of the claimant's cause of action. On the other hand, the attempt to estimate what benefit the claimant has lost as a result of the defendant's breach of contract or other wrong can sometimes involve considerable uncertainty, and courts will do the best they can not to allow the difficulty of estimation to deprive the claimant of a remedy, particularly where that difficulty is itself the result of the defendant's wrongdoing. And just below letter B, the judge says the court is aided in this text by what may be called the principle of reasonable assumptions. And then between E and F, his lordship quotes from Wilson and Northampton Railway, plaintiff will be entitled to the benefit of such presumptions as according to the rules of law are made in the courts both law and equity against persons who are wrongdoers in the sense of refusing to perform and not performing their agreements. And then at 190, seems to me that the rebuttable presumption that the claimant would have recouped expenditure incurred in reliance on the defendant's performance of the contract is an illustration of this approach. Parties in normal circumstances contract and incur expenditure in pursuance of their contract in the expectation of making a profit. Where money has been spent in that expectation but the defendant's breach of contract prevented that expectation from being put to the test, it's fair to assume that the claimant would at least have recouped its expenditure had the contract been performed, unless and to the extent that the defendant can prove otherwise. And then at 191, applying this approach to the present case, ITC has not attempted to discharge the burden of showing what financial return Yam Seng would have made if ITC had not been in breach of the contract. And then at 192, he concludes that Yam Seng is entitled to recover as damages for ITC's breach of contract its wasted expenditure incurred in performing the agreement. And just standing back from Yam Seng, one can see that the ability to claim wasted expenditure is a valuable right in practical terms, an incredibly valuable right. And that brings me to the principles we set out in our skeleton. If we could just turn that up, please, in Core Bundle tab 2, beginning at page 13, and if we go to page 20. And at paragraph 27, if the court has that, we set out the general principle that the hypothetical reasonable person would be unlikely to conclude that the parties intended to produce an unfair result, including by abrogating an important common law remedy, without clear words to support such an outcome. We cite Lewison on contracts, on the interpretation of contracts. Lewison identifies clauses which exclude common law remedies or damages for breach of contract as specific applications of this principle. And we cite from a trilogy of cases, which will be familiar to the court, Gilbert Ash, House of Lords in Gilbert Ash, Seadrill in the Court of Appeal, and then paragraph 29, the Stochnia case where Lord Justice Morbick said the court is unlikely to be satisfied that a party to a contract has abandoned valuable rights arising by operation of law unless the terms of the contract make it sufficiently clear that that was intended. The more valuable the right, the clearer the language will need to be. And we say that is a very important principle of construction. And the judge was alive to that principle of construction because she referred to it in another context. Just to give you the references, it's paragraphs 346 and to 348 of her judgment. But in our submission, she failed to take it into account in construing clause 23.3. And one can see a fairly extreme application.
Sorry,
of that.
I'm
sorry, my lord.
Yes, I see. So certainly a couple of those authorities are referred to by the judge in her analysis on the different point about set-off.
Indeed, that's correct.
Yeah, thank you.
And a fairly extreme example of that principle is from the Kudos catering case in the Court of Appeal, which I cite with some diffidence because my Lord Justice Phillips was in it. For what it's worth, it does seem to me that your construction and Mr. Kramer's construction of the clause was fairly clear. But it's an illustration of just how extreme this principle can be in application. And you'll see it's behind tab 11 of bundle 2 of the authorities bundle. Page 269 of the and looking at the head note, by a written agreement concluded in April 2007, the defendant referred to in the agreement as the company appointed the claimant referred to in the agreement as the contractor, exclusive supplier of catering services at those two venues for a 5-year period beginning the 1st of April 2007. And you see the bottom of that last paragraph on the left-hand column. Disputes subsequently arose between the parties. On 1st of July 2010, the defendant wrote to the claimant purporting to terminate the agreement on 1 month's notice pursuant to a contractual provision. The claimant in turn wrote the defendant on 8th of July 2010 purporting to treat the defendant's actions as a repudiatory breach of the contract, except the same as terminating the agreement. And then in the right-hand column, beginning with the second paragraph, you can see the clause 18.6. Defendant contend its liability in respect to the claim for lost profits precluded by clause 18.6 of the agreement. You'll see that provides, contractor hereby acknowledges and agrees that the company shall have no liability whatsoever in contract, tort, including negligence or otherwise, for any loss of goodwill, business, revenue or profits, anticipated savings or wasted expenditure, whether reasonably foreseeable or not, or indirect or consequential loss suffered by the contractor or any third party in relation to this agreement. It's hard to imagine a more comprehensively drafted exclusion clause. But if we go on, please, to paragraph 21, internal page 276, paragraph 21, footed page 276 in the internal law reports. Lord Justice Tomlinson cites Lord Clark in the Rain Sky case. I think you'll all be familiar with that passage. So his first point is as a matter of construction, and then in the middle of the left-hand column on page 277, looking at the law report, numbering. After the citation from Lord Justice Hoffman, in the middle of the page, Lord Justice Thomson said, there also in my view comes into play the presumption that neither party to a contract intends to abandon any remedies for its breach arising by operation of law. Lord Diplock went on to say that clear words must be used to rebut this presumption, and the judge plainly thought the words here used were sufficiently clear for that purpose. And you'll see, if you go back to the head note, paragraph, page 2, Internal Law Report, page 271, you see at 1, they held that the defendant's construction of the clause would reduce the contract to a mere declaration of intent, which wouldn't be consistent with business common sense, and that's the rainy sky point. And then there also came into play the presumption that neither party to a contract intended to abandon any remedies for its breach arising by operation of law. And then if we go to holding 2, halfway down, construing the agreement as a whole consistent with business common sense and giving effect to the presumption that parties do not lightly abandon remedy for breach of contract afforded them by the general law. The expression in relation to this agreement in clause 18.6 meant in relation to the performance of this agreement, the exclusion related to defective performance of the agreement, not to a refusal or to a disabling ability to perform it. Had the parties intended to provide an exclusion of all liability for financial loss in favour of the company and not the contractor, in the event of refusal or inability of the company to perform, they would have spelt that out clearly. It's an extreme case, but it was also an extremely widely drafted clause. And on its face, it's hard to see why it didn't apply to the loss claim, but one can see how strong the principle in the Stochnier case and others is. My Lords, with that, perhaps it would make sense to look at the OMAC decision of Mr. Justice Tier. It's Authorities Bundle 2, tab 16. And if one just looks at the head note, page 453 in the bundle, and looks at the head note, we can see why Mr. Justice Tier was exercised by the result sought in this case, because the claimant owners, defendant charterers, entered into a long-term charter party. Charter was terminated as a result of the owner's acceptance of the charter's repudiation of the charter party. At that point in time, the market rate of hire was higher than the charter party rate. As a result of the owner's acceptance of the charterer's breach, the owners were able to trade the vessel at the higher market rate and were not restricted to trading the vessel at the lower charter party rate. They nevertheless claimed damages, namely the expenses that they had incurred in preparing to perform the charter party and making certain modifications to the vessel required by the charterers prior to delivery, including the installation of a new crane. The arbitral tribunal held that the owners were entitled to such damages, notwithstanding that they had not suffered any net loss, and that they had more than recuperated the losses that they claimed in the arbitration. And over the page, between letters E and F, you can see His Lordship concluded that towards substantial damages measured by wasted expenditure, where the owners had, as a result of the charterer's breach, been able to trade the vessel at the higher market rates and had more than recuperated their loss, would be wrong in principle. Such an award would place the owners in a better position than they would have been had the contract been performed, etc. And he goes on to say that he could have reached the same conclusion by applying principles of mitigation. And just picking up a few references. A lot of the core points are dealt with by Mr. Justice Leggett in Yam Sang, but we'll pick it up at page 460, internal 162, paragraph 19. Paragraph 19, Mr. Justice Tier says the law of damages permits a claimant to seek damages on the reliance basis rather than on the expectancy basis. He may elect to claim damages by reference to the expenses incurred by him in reliance on the contract being performed. You see the references there. Paragraph 20, in the present case, the claimants, having abandoned their claim to damages on the expectancy basis, claim damages in the sum of the expenses incurred by them in reliance on the contract being performed. There is no dispute that damages may be claimed on that basis, but the question raised by Mr. Brenton's submission is whether, and if so, how the principle in Robinson and Harman applies, so as to ensure that the claimants are not put in a better position than they would have been in if the contract had been performed. It says at 21, there is considerable authority both in other common law jurisdictions and in this jurisdiction for the proposition that the recovery of damages on a reliance basis is governed by Baron Park's principle in Robinson and Harman, given the fundamental nature of that principle. It's not surprising. You see he cites from the Chief Justice in the following paragraph, and you see the material part of that. And if we go on to paragraph 47, internal page 168, paragraph 47, he says, the authorities therefore state a rational and sensible explanation for the view that the expectation loss principle underpins the award of damages in wasted expenditure cases. In some cases, a contract can be shown to be a bad bargain. In other cases, it may not be possible to show one way or the other whether the likely gross profits would at least equal the expenditure. In that latter type of case, the question arises as to which party should bear the evidential burden of proof. Should the burden be on the claimant to show that the likely profits would at least equal his expenditure, or on the defendant to show that the likely profits would not at least equal the claimant's expenditure? The authorities to which I have referred provide a rational and sensible explanation of the view that the burden should be on the defendant. And then finally, I think paragraphs 55 to 56. Paragraph 55, he says, I'm not therefore persuaded that the right to choose or elect between claiming damages on an expectancy basis or on a reliance basis indicates that there are two different principles at work. Both bases of damages are founded on illustrations of the fundamental principle in Robinson and Harman for the reasons explained in Albert and Armstrong and by Justice Berger in the Bole logging case, and by all members of the High Court of Australia in the Amman case, etc. And then 56, Mr. Brenton has a further criticism that there are many contracts but it does not expect or aim to make a profit, such as where purchases are made for pleasure or for charitable purposes. Just the expectancy base would deny recovery of wasted expenditure in such cases. I disagree. In such case, the defendant will usually be unable to show that the expenses exceeded the benefit expected to be obtained in the contract, and thus the expense will be recoverable as damages. And again, that's inconsistent with the need to try and distinguish between pecuniary and non-pecuniary benefits flowing from the contract. So, looking at those cases, we of course accept that there is one overall aim of compensatory damages and that the expectation interest prevails. But it is not right to say that reliance damages do not exist. They do, and analytically they protect a somewhat different interest, always subject to the compensatory principle. And could the court please take Authorities Bundle 3, tab 20. Just a short passage in the judgment of Lord Justice Steyn, internal number, internal page number 1369. I think it's 548 in the electronic bundle. If you have that in Lord Justice Staines' judgment, just below letter B, His Lordship says an award of compensation for breach of contract serves to protect three separate interests. The starting principle is that the aggrieved party ought to be compensated for loss of his positive or expectation interests. In other words, the object is to put the aggrieved party in the same financial position as if the contract had been fully performed. But the law also protects the negative interest of the aggrieved party. If the aggrieved party is unable to establish the value of a loss of bargain, he may seek compensation in respect of his reliance losses. The object of such an award is to compensate the aggrieved party for expenses incurred and losses suffered in reliance on the contract. These two complementary principles, i.e. positive and negative interests, share one feature. Both are pure compensatory principles. If the aggrieved party has suffered no loss, he is not entitled to be compensated for invoking these principles, i.e. either of them. And then he goes on to refer to the third principle being the aggrieved party's restitutionary interest, which we needn't spend time on. That neatly encapsulates what clause 23.3 appears to have been primarily focused on. The analysis in the Surrey County Council case of Lord Justice Steyn remains the characterisation of the relevant interest protected by an award of compensatory damages, adopted in the current editions of all the leading texts. They're not in the bundle, we can provide copies if necessary, but can I just read some references into the transcript? Chitty, 34th edition, 2021.
Hang on.
Sorry, my lord. Chitty, current edition, paragraph 29-022.
Thank you.
Benjamin, sale of goods, also 2021, 11th edition, at paragraph 17-062. McGregor, also 2021, 21st edition, at paragraph 4-025. And Tritle, 2020 edition, 15th edition, paragraphs 20-30 to 20-32. And I'm just going to take the court to one textbook, which is Professor Burrows, as he then was, Restatement on the Law of Contract, Authorities Bundle 3, tab 24. And behind tab 24, see an extract from the restatement. And the principles set out in Article 20 under compensatory damages. Number one, where there's been a breach of contract, the claimant has a right to compensatory damages, which A, have the purpose of providing a monetary equivalent to the claimant's loss caused by the breach. And then we can go to subparagraph 2. The aim of compensatory damages for breach of contract is to put the claimant into as good a position as if the contract had been performed. And then if we go, please, to subparagraph 7, in applying the aim in subsection 2, i.e. the compensatory aim, the claimant can choose, as an alternative to a direct assessment of the position it would have been in if the contract had been performed, to be compensated for the wasted expenses or other losses incurred in reliance on or in anticipation of the contract. By making this choice, the claimant should not be put in a better position than if the contract had been performed, i.e. OMAC, and the defendant has the burden of proving that the claimant will be put into that better position, i.e. Yam Seng. And then if we go to the discussion on Article 27, 20 subparagraph 7, go to bundle page 702, internal numbering 129. And third of the way down, Professor Burrows said, considerable confusion about the role of so-called reliance damages in contract. Confusion stems from a famous article by Fuller and Purdue, which has fueled the belief that in contract, reliance damage is an alternative aim of damages to the normal expectation aim. At least as far as English law is concerned, it's now clear that this is a myth. Putting to one side negotiating damages, there is one overall aim of compensatory damages, seeking to protect the expectation or performance interest, and so-called reliance damages are merely a method of achieving that single aim. A claimant, instead of directly seeking its lost profits, can alternatively claim its reliance loss, but as the aim is still to put the claimant into as good a position as if the contract had been performed, two features follow. One, a claimant cannot escape from what the defendant proves to be a bad bargain. And two, even pre-contractual expenses may be recoverable. The formulation in the restatement stressing losses in anticipation of the contract and that the claimant should not be put into a better position than the contract being performed, and the defendant has the burden of proving this, covers both these features. And you can see the authorities that Professor Burrows refers to. Now, there are a number of articles by law firms and barristers expressing some surprise at the outcome of this case. I have not troubled the court with these, but there is one article by Professor Peel which considers both the present case and the Atos case, and in my submission it may be of assistance to the court. So I was going to, before I conclude on this topic, take the court to that if I may. It's in the same bundle we were in a moment ago, behind tab 26. Hopefully it's page A716. You should have an article headed Excluding Liability for Wasted Expenditure, CIS against IBM. And so he refers to the decision of Mrs. Justice O'Farrell in CIS and IBM, which raises a number of issues. This note focuses on just one of them, namely whether a claim for damages pleaded on the basis of wasted expenditure fell within an exclusion clause which made no express reference to wasted expenditure as an excluded head of loss. Then he summarises in the following paragraphs the salient facts of the case, which the court is familiar with, and I needn't take you to them, but it's an accurate and careful summary.
And this is Peel, is this? The author of this?
It's Professor Edwin Peel, and you can see that if you look.
Page 722.
Indeed, just from the asterisk at the bottom of the page.
I mean, speaking for myself, you will understand that we often get shown articles and pieces in which people suggest that the case under review is incorrect. And speaking for myself, I don't often find those of any great assistance. What I am interested in, however, is I think you suggested that he also touches on the Atos case,
yes.
And that speaking for myself, is of more direct relevance, I think. So I'd be interested to see that.
I'll show you, indeed I'll show you that. Just to show you the framework of the article,
Yeah.
the following page, he summarises the principles on which the judge reached her conclusion, which you'll be familiar with from having been taken through the relevant passages. So I'm not going to go to that in the middle of the page. you'll see he refers to the fact that it's presumed that if the contract had been performed, the claimant would at least have recouped its expenditure unless the defendant is able to prove otherwise. And it gives an example there. And then if we go, touching on my Lord's question, to the top of page 427 of the article,
Yeah.
Mrs. Justice O'Farrell applied the proposition set out above to reach the following conclusions. One, she identified the benefits or loss of bargain which CIS hoped to achieve from performance of the contract as the savings, revenues and profits that would have been achieved had the IT system been successfully implemented. Although CIS claimed damages of 128 million on a wasted expenditure basis, and he quotes, that simply represents a different measure of quantifying the loss of bargain. And three, accordingly, since clause 23.3 excluded liability for loss of profit, revenue or savings, it also excluded a claim for wasted expenditure. And then he says, before commenting on the decision and the reasoning and support, two further points need to be noted. First, Mrs. Justice O'Farrell had previously dealt with this issue in the Royal Devon and Exeter Foundation Trust case, in which she had come to a different conclusion. And he summarises the facts of the Atos case, referring in the quoted passage to the non-pecuniary pecuniary benefit analysis. And I think I've taken the court to those passages.
Yeah.
And two-thirds of the way down, in the CIS case, Mrs. Justice O'Farrell relied on those passages to distinguish the Royal Devon case on the basis that the loss suffered in the latter was non-pecuniary benefit that was not caught by the exclusion. There is no deliberation beyond this observation. And then, touching even more directly on what your Lordship is interested in, if you go to the following page, second paragraph, by way of an initial comment, it's a little difficult to see how Mrs. Justice O'Farrell's decisions in the CIS case and in the Royal Devon case can both be correct. Put in simple terms, the claimants in the Royal Devon case was entitled to recover its wasted expenditure because that amounted to a claim that it did not get the very thing for which it had contracted, i.e. functioning EMR system, and that was a benefit not covered by the references in the exclusion clause to loss of profits or savings, etc. But equally, on the hypothesis that it was left with no part of the IT system, the claimant in the CIS case did not get the very thing it contracted for, i.e. a functioning IT system, and that too was a benefit not covered by the references in clause 23.3 to loss of profits or savings, etc.
Well, that was my Lord's point to you earlier.
Indeed. No doubt the NHS Trust's ultimate aim in the Royal Devon case was not to make profits as such, but one would, I'm just pausing there, I'm not sure that's actually right in terms of the way in which NHS Foundation Trusts are set up, because they do actually have profit making as part of their remit, but that's quibbling. No doubt the NHS Trust's ultimate aim in the Royal Devon case was not to make profits as such, but one would like to think that even an NHS Trust might be interested in being financially efficient, so that the benefit of the EMR system might be said to lie in the savings to be obtained through its use. The response to this submission may be to say that the NHS Trust would only make savings once it had also got what it paid for, but why should something similar not be said in the CIS case? CIS had spent 128 million. Only when the benefit obtained in return began to exceed 128 million would it be correct to say it was making a profit or any savings. So when it sought to recoup the wasted 128 million, not indirectly making a claim for profits or savings. This could, of course, give rise to some difficult questions. When is the point reached at which the benefit exceeds expenditure? Which may also engage the question of what is the relevant benefit or the very thing for which the claimant has contracted. But this is a problem for the law of damages and is not a new problem. For example, it has been recognised in a contract for services not receiving the benefit of the services themselves or receiving inferior services can itself be regarded as a relevant loss, whether or not it has any further pecuniary consequences. As Sir Thomas Bingham, Master of the Rolls, put it, it is obvious that in the ordinary way, a party who contracts and pays for a superior service or superior goods and receives a substantially inferior service or inferior goods has suffered a loss. There's a reference to the White Arrow case in footnote 17. But if the obvious measure of that loss is the court's assessment of the difference in value between the service provided and what should have been provided, that is a sum which is likely to be reached by an extrapolation from the price. What this leaves out of the account is any expenditure of the claimant in addition to the price. In the CIS case, the price paid to IBM was a significant part of the expenditure, but only part. As far as an exclusion clause like clause 23.3 is concerned, the question raised is what the parties meant when they refer to heads of loss, such as loss of profits or savings. But there are several reasons to support the view that they mean net profits or net savings. First, the outcome in the CIS case is stark. As noted above, even if CIS had received no benefit at all prior to termination of the contract, the effect of clause 23.3 was to exclude recovery of any part of its expenditure of 128 million. And then it says, whilst some judges have called into doubt the utility of the doctrine of contra proferendum, it's hard to see how this fits with the tendency of the court still to adopt a narrow construction of an exclusion clause on the basis that it cuts down or detracts from the ambit of some important obligation in the contract. And we'd add to that the principles I averted to based on Gilbert Ash and Stochnier and so on. What does fit with that approach is an interpretation of terms such as clause 23.3, which results in the parties having agreed that the defendant is not liable for not having made the claimant better off as a result of the breach of contract, no liability for net profits or savings, but is liable to the extent that the claimant has been left worse off in the sense that it did not even get what it paid for. And that, I think, chimes with a point which my Lord Justice Phillips put to me at the outset in terms of the balance internal to clause 23.3. I'm not saying it's a perfect analogy, but it does fit with why wasted expenditure and reprocurement would fall on one side of the line, and loss of profits and savings and revenue would fall on the other side of the line.
What is, I understand that, what is that approach to which he refers 5 lines up? What does fit with that approach?
I think it's the approach of adopting a restrictive approach to exclusion clauses.
Right. Not contra proferendum.
No.
Which in 20 years I've still not had a case turn on.
No.
And I hope to maintain that until I retire.
No, for avoidance of any doubt, we do not rely on the contra proferendum.
No. Well, I understand that, but I was just the grammar isn't perfect, but you say that that approach is the narrow construction point.
Yes, and he refers, Professor Peel refers to, in that context, a decision of Mr. Justice Briggs, Lord Justice Briggs, as he then was in the Hutt Group, which refers to the principles, in fact, that we've not put it before the court because it's just adding to more of the Gilbert Ash type cases.
Yeah.
Stochnier, but in Hutt Group, his Lordship, Lord Justice Briggs, makes the point that the parties aren't likely to be taken to have excluded valuable rights without expressly saying so.
Yeah.
When you're looking at the principle that's set out most clearly in who was then Professor Burrows, 27, that the defendant, the claimant can't obtain more than they would have claimed had the contract been performed. Imagine that the expectation or the loss of bargain on the approach that my Lord Justice Phillips put forward earlier was X, but there was Y profits that might have been made on top of that. Is one looking at only at X in terms of the figure you have to meet?
Is that a scenario where the waste expenditure might be greater than?
Yes.
I think that's right, because on the bad bargain hypothesis, you can't recover more. Your waste expenditure will be capped by reference to what you expected to make on the contract. I think that's right.
Well, but you would have expected to make profits in addition. That's why I asked the question. But you say
It's balanced by expenditure rather than profits in that context. So the cases, I think Jan's saying makes clear that you would have recouped expenditure at least to recover your wasted expenditure. Sorry, revenue to at least recoup your expenditure.
right. But where does that fit into the analysis? Mine was. I think the question I was asking was where X is the loss of bargain. So let's say it would have cost you X to replace the thing you had lost, and that's the value of the lost bargain, and that's X. Is X the cap in terms of wasted expenditure?
Yes, assuming X deducts the wasted expenditure that would have been required to get there. I'll give some further thought to that. I think that's how I'd put it. And then I think in the light of your Lordship's indication as to what interested you, you can see he makes further
Well,
points.
we can read. I mean, he may make other criticisms
Read it,
of
and I
that.
think if perhaps I can just go to the final paragraph.
Fine.
See, the comments made above lead to the conclusion that Mrs. Justice Zacaroli may have been incorrect, so that clause 23.3 excluded liability waste expenditure, and that her decision in the Royal Devon case is to be preferred without confining it to so-called cases of non-pecuniary benefit. Prudent drafter who wishes to exclude liability for waste expenditure will of course make express reference to that head of loss, but even then there remains a question of what exactly has been excluded, etc. And the court can see what else the professor says there. So I hope that's been some assistance.
Thank you.
My Lord, the only case which we found which deals in terms with Her Ladyship's decision in this case is another first instance case called Galtrade, and I know my learned friend relies on it. I'll probably wait to deal with it and reply. It doesn't really add very much because he was dealing with a different clause, and his conclusion was that it was much narrower than the clause in issue in our case below. The decision of Deputy Judge Mr. Beltrami QC, I wasn't going to go to it in opening, but I'll deal with it in reply depending on how my friend addresses it, if I may. My Lords, in conclusion on clause 23.3, we say that the reasonable person test is the paramount rule of contractual interpretation and cannot be sidestepped, as IBM contends. And IBM does not seriously seek to uphold the judge on the basis of any application of the ordinary meaning of words or the reasonable person test. Had the judge construed the clause properly, rather than simply through the prism of legal theory, she ought to have held in our respectful submission that clause 23.3 of the MSA does not exclude a claim for wasted expenditure for the reasons we set out in our skeleton paragraphs 21 to 38 and as developed today. And the key to this is the absence of any reference to wasted expenditure in clause 23.3 and the strong presumption against the parties excluding valuable rights without clear language to that effect.
Yep.
So, my Lord, the second issue is whether IBM's AG5 invoice was disputed in good faith, and the judge held that it was. The issue is, I'm not going to turn it out, but the issue is addressed in our supplementary skeleton at paragraph 6 to 26, and the judge addressed the issue, again not turning it up at the moment, paragraphs 317 through to 330. We'll come back to all parts of that But for your Lordship's reference, our analysis of the whole AG5 invoice issue begins at paragraph 254 of her judgment. And it's useful, if I may, just to summarise the position that had been reached by the time the AG5 invoice was submitted in January 2017. Sorry, AG5 invoice became due in January 2015 and was submitted in March 2017. So by way of summary, the contractual go-live dates were May 2016 for release 1, that's household insurance, that's 11 and a half months after contracting, and 15th of August 2016 for release 2, motor insurance, that's 14 months after contracting. References, judgment at paragraph 7, 1 to 2. There were significant delays in implementation for which IBM and its subcontractor were responsible. Judgment, paragraphs 657 to 660. By the date of termination, 28th of July 2017, my client had reasonably spent, as we've seen, £122.6 million on the project. The last projected go-live dates that IBM had identified before termination were November 2017 for release 1, that is 18 months later than the 11.5-month contracted for date, and March 2019 for release 2, that is 31 months later than the 14-month contracted for date, and some 20 months in the future. That is the judgment at paragraph 181. And then flowing from that, IBM knew that its AG5 invoice sent out on the 24th of March 2017 would be controversial in the light of those substantial delays. See the judgment, paragraph 264. There was accordingly, as the judge found at paragraph 289, no great surprise on IBM's part when my clients declined to pay the invoice. When IBM told Sysgill that it wanted its AG5 invoice for £2.9 million to be paid, Sysgill refused to provide a purchase order number to enable IBM to submit a valid invoice, and we'll look at the relevant contractual provisions. Because it believed in good faith, albeit incorrectly as the judge held, that payment had not yet fallen due by reason of the substantial delay. That is judgment paragraphs 256 and 328. Now,
Paragraphs 256,
256 and 328.
328. Thank you.
Now, just by way of background, the actual AG5 invoice was simply sent to Sysgill's accounts department by email. It was not sent to members of Sysgill's project team who were unaware of it and would have been in a position to dispute the invoice on wider grounds. As IBM notes, the project team became aware of the invoice in late April. See IBM's main skeleton at paragraph at footnote 45. And of 127 invoices rendered prior to the AG5 invoice, under cover of 36 different emails, only one previous invoice had not been copied to Sysgill's project team. And we give the references for that in our supplemental skeleton at footnote 2, and see also the judgment at paragraph 311. And against that background, the relevant question for the judge was a simple one. Did Sysgill dispute the AG5 invoice in good faith? And she held that it did. We'll come back to it, but the reference is judgment, paragraph 330. So the first question is whether there was a dispute raised within the meaning of the contract. And the critical email is from Miss Clough in Siskel's accounts department, which the court will find in the supplemental bundle at tab 9, page 135. And you'll see that this is an email from Rachel Clough, dated the 27th of March 2017. And she says, in the first substantive paragraph, please can this invoice be resubmitted with the correct purchase order number quoted on it. In the second paragraph, we cannot accept this invoice for payment without a purchase order number quoted on the invoices. Now, IBM mischaracterised Miss Clough's email in its skeleton at paragraph 40. They say that she simply made an administrative request for the invoice to be resubmitted with a purchase order. What Miss Clough in fact requested was a purchase order number, as you see, and her second line unequivocally, the judge found, refused payment because no purchase order number was quoted. And that was an invocation of the contractual machinery. If we go back in the same supplemental bundle behind tab 4, page 94, this is in Schedule 5 to the MSA. Perhaps we can start at 11.7. 11.7 at the foot of page 94, unless the contractor disputes an invoice in good faith, in accordance with the above paragraphs in the Schedule 5, the customer shall pay correctly prepared invoices, properly submitted in relation to payments to be made under this agreement within 7 business days of receipt. And then at 11.11, if at any time the customer acting in good faith disputes an invoice or an amount shown in an invoice delivered by the supplier, the customer should pay the undisputed amount, if any, of the invoice within the period required under paragraph 11.7. And just to note, we would submit the quid pro quo of the timescale of 7 days was that little can have been required by way of formal requirements to constitute a dispute, notification of a dispute, and the contract doesn't identify any. There's nothing to suggest that disputes bears any sort of special meaning. If you look at paragraph 11.4b, this is a requirement, 11.4b, unless otherwise agreed by the parties, each supplier invoice shall quote the relevant statement of work identifier and the unique customer purchase order number. So on its face, the invoice didn't comply with the contractual stipulation for a purchase order number, and Siskel notified IBM in good time, i.e. 3 days I think, that it would not be paid for that reason. And in those circumstances, how can, we would ask, Siskel's refusal to pay for that reason be something other than Siskel disputing the invoice? Now, IBM submits that an email from an invoicing clerk which didn't refer to the contractual dispute resolution machinery would not be understood as deliberately invoking and binding the parties to engage in that dispute resolution machinery. But in our submission, that is a straw man, because the contract doesn't say that Siskel has to do any of those things in response to an invoice in order to suspend its obligation to pay. All the contract required was Siskel to dispute the invoice in good faith. Then, if one party, probably IBM in this context, wanted to invoke the dispute resolution machinery, which is set out in Schedule 10 of the agreement, I'm not going to turn it up, but it's behind tab 6 of the same bundle, it was free to do so. as the judge held, neither party invoked that machinery, despite the fact that IBM recognised on its own system that the invoice was a disputed invoice. And that's judgment paragraph 329. And I wasn't going to spend time turning it up, but the contract, as I said, required no magic formula required of Miss Clough to signal a dispute being raised. And I was going to take your lordships to Manai, which deals with contractual notice provision. Perhaps it would be useful actually just to go to it quickly. It's at Authorities Bundle 2, tab 13. And bundle number, page 364, internal report, page number at the top, 767. We can skim through this fairly quickly, but we just take it from subparagraph 1 on page 767. Lord Steyn says this is not a case of a contractual right to determine which prescribes an indispensable condition for its effective exercise, that the notice must contain specific information. And we say that is analogous to our case. And then paragraph 2, the question is not how the landlord understood the notices. The construction of the notices must be approached objectively. The issue is how a reasonable recipient would have understood the notices. And then if we go to the next page between letters B and C, Lord Steyn says the inquiry is objective. The question is what reasonable persons, circumstance as the actual parties were, would have had in mind. Follows that one cannot ignore that a reasonable recipient of the notices would have had in the forefront of his mind the terms of the leases. And then C, the question is simply how the reasonable person would have understood such a notice. And then at E, prima facie one would expect that if a notice unambiguously conveys a decision to determine, the court may nowadays ignore immaterial errors that would not have misled a reasonable recipient. And with that, if we could go to the judgment itself of Mrs. Justice Zacaroli, or bundle tab 7, and see her.
I mean, there's plenty of authority, isn't there, about what constitutes a dispute for purposes of arbitration and in particular adjudication, because it's so regularly said that the notice of adjudication was served before there was a dispute.
Yes.
So there's quite a lot of it's a relatively low threshold.
Indeed, and
An assertion and a response.
my lord, yes, and particularly so when looked at in the context of this contract, because the contract doesn't identify any specific hoops that have to be jumped through to indicate a dispute. There is a separate dispute resolution machinery which you can specifically invoke, but in our submission, the 7-day stipulation in particular points to a relatively low threshold on the facts of this case and on the background contractual provisions.
What do you say is the minimum? Is it enough to say we're not paying? Or must be some reason put forward as well?
I mean, if you pin me down, I would say we're not paying would be good enough to signal a dispute, but Ms. Clough in this case goes further and identifies a contractually stipulated basis for refusing. And in our submission, that is good enough. If the invoice had been sent to the projects team, we would have got, IBM would have got it with both barrels, to put it colloquially, in terms of the substantial delay, this is why you're not entitled to payment, and so on. The judge held that would have been wrong, but it would have signalled a much bigger and wider range of dispute. But in our submission, this was enough.
Yeah, it might be that I'm not paying, might not be a dispute in good faith.
Indeed, if there's no justifiable basis for that. I mean, it may be against the background known to the parties, I'm not paying, would be well understood because of what had gone before as to why they refused to pay, but it depends on the context.
Well, the clause actually requires a statement of the reason for non-payment.
Yes. I don't think it does. This clause requires the indication of a dispute, so you'd have to say the invoice was disputed.
It's 1111.
So I guess the good faith requirement. Sorry, I better have the clause in front of me. Yes, it's if at any time the customer acting in good faith disputes an invoice or an amount shown in an invoice, so it doesn't go any further than 11.7.
So forgive me, can you give me the reference again?
I'm sorry, it's supplemental bundle, page 95.
It goes on to say,
Oh yes, sorry, I'm very sorry. Your Lordship has in mind reasons for disputing the relevant part of the invoice at the end of 11.11.
yes.
You're quite right.
And presumably you'd accept that's not limited to where part is disputed, but part isn't. It must apply
Yes.
generally. So, the contract provides that there needs to be a reason. You say, well, the reason is stated because there was the lack of that.
Yes. I mean, it's the only reason that Miss Clark would have been in a position to give on
Yeah.
fact, but there it is.
Now you were taking us to the judgment.
Indeed. So if we could go to the call bundle, tab 7. And page 160. And does the court have paragraph 323?
It's 323 to 330, isn't it? Is her
Yes.
analysis.
Indeed. Does the court just wish to read that, or shall I read the relevant?
I think we'll read that for ourselves.
I'm obliged. You'll see at the end of 324, her ladyship said that she accepted Siskel's submission that under paragraph 11 of Schedule 5 that sufficient notification for the purpose of placing the AG5 invoice in dispute. And at the end of 325, the only sensible interpretation of those words, Siskel disputed the invoice submitted and indicated that it would not pay it. And she makes the point that it was obviously appreciated as a dispute on the part of IBM because of the way it categorised it. So in terms of the Manai principles, in terms of how it would have been understood even subjectively, there can't be any doubt that it was understood that the invoice was disputed. And then you see a conclusion at 327 that the invoice was disputed in good faith, which brings me to my next point. Because that conclusion is also challenged by IBM. And we say there's a fundamental problem on this limb for IBM because the judge held that Siskel's ultimate decision maker, Mr. Summerfield, its CEO, withheld approval for a purchase order in good faith. IBM doesn't challenge that and expressly does not assert that anyone else, including Ms. Clough, acted in bad faith at any time. There's two stages that make up the chain of events are quite straightforward. I mean, first of all, Mr. Summerfield refused to authorise a purchase order number for milestone AG5 because he didn't think the milestone had been achieved due to delays for which the judge held IBM was responsible. Secondly, Ms. Clough refused payment because there was no purchase order number on the invoice, which, provided she was doing her job properly, would inevitably follow from Mr. Summerfield's decision to withhold the purchase order number because a purchase order number was required under Schedule 5. In fact, Mr. Summerfield was wrong to withhold a purchase order from IBM because, as the judge held, the AG5 milestone fell due on a fixed date, not on the achievement of a particular stage of performance by IBM. But the judge held that he made that error in good faith, and IBM does not assert that Mr. Summerfield did not genuinely believe that Siskel was entitled to refuse to pay on the ground that the relevant payment had not fallen due as a result of the delays. And IBM has never contended that Ms. Clough was not acting in good faith when she disputed the AG5 invoice. Now, IBM relies on several authorities on good faith. I wasn't going to traipse through all of those. We respond to those in our supplemental skeleton at paragraphs 19 to 23. Just want to take the court to one case which may shed light, which is the decision of Mr. Justice Voss, as he then was, in the CPC case, Authorities Bundle 1, tab 7. And page 90, you see that the relevant contract had a good faith obligation in clause 7.1. And then if we go on to page 149, and paragraph 246 at page 149, Mr. Justice Voss said, second half of the paragraph, I do not need, it seems to me, to decide whether this obligation could only be broken if QD or CPC acted in bad faith, but it might be hard to understand, as Lord Scott said in Manifest Shipping, how, without bad faith, there can be a breach of a duty of good faith, utmost or otherwise. And the learned judge below obviously saw the witnesses, saw Mr. Summerfield. The conclusion that he acted in bad faith and he acted in good faith and did not act in bad faith is hard to question on appeal. I'd also pray in aid, I don't like to turn it up, I'm just going to give some references. The decision of the Supreme Court, the recent decision in the Pakistan International Airlines case, we give the references to the judgments of Lord Hodge and Lord Burrows at paragraph 14 of our main skeleton, of our supplemental skeleton. It's in the authority bundle at authority bundle 2 at tab 17, but I'm not going to spend time turning to that now.
Is there any other authority on the issue touched on at paragraph 246 by Mr. Justice Boss?
And there are lots of authorities on good faith.
No, I know that. Most of them are Lord Leggett.
Yes.
But the particular issue, as we get used to duties of good faith and relational contracts, the question, well, must you be acting in bad faith to be in breach of a duty of good faith? Which I'm bound to say is a question that has occurred to me more than once. Is there anything else on that point other than the reference you've taken us to here that you're aware of?
I don't believe so. I mean, there is the line of authorities in relation to contractual obligations of good faith, where there's talk about fidelity to the bargain and so on.
And acting in a commercially unacceptable way.
Indeed.
But if that's the duty of good faith, and it's found that you haven't acted in a commercially acceptable way, logically you must have acted with bad faith.
Yes, in my submission, there would normally be two sides of the same coin.
Yeah. Okay. Sorry, that was just a question that's occurred to me before. Yeah. So we don't need to look at Pakistan International Airlines, but that's the most recent case.
That's the most recent
on
case.
Good faith.
It's in the context of unlawful act duress.
Yes.
Basically, what Lord Hodge says is that if you genuinely believe you're asserting a contractual right, you won't be acting in bad faith for the purposes of unlawful act duress.
But if you make a demand which you know or are pretty sure is a bad demand, then the opposite may be the case.
Yes. Yeah. It's technically overture because Lord Burrows advocated in that case that bad faith should be the guiding principle for lawful act duress, and the majority said no. But in analysing what good faith and bad faith means, you would be acting in good faith if you genuinely believed you're entitled to make the demand that you made, and that's the effect of the citations we give.
Yeah.
So here you would say that the dispute is made in good faith. If you have a genuine belief that you have a reason to dispute it.
Indeed. And it's very hard to question the judge's finding so far as Mr. Summerfield's genuine belief or good faith is concerned, given that the judge obviously saw Mr. Summerfield give evidence. The final point under this heading, to deal with it before the short adjournment, final point IBM makes is the prevention principle, which is namely that my clients cannot take advantage of its own wrong to come within clauses 11.7 and 11.11 of Schedule 5. Now, the judge relied on that principle as to why we weren't entitled to withhold payment of the AG5 invoice by not issuing a purchase order. So she said we were still obliged to make the payment, and we couldn't rely on the failure to issue a purchase order to say that the payment obligation hadn't accrued in January. But this is a different question when we come to Schedule 5. The question in relation to clauses 11.7 and 11.5 of Schedule 11.11 of Schedule 5 is whether the invoice was disputed in good faith. And good faith is the relevant touchstone here. The contract does not require an objectively valid dispute or a dispute ultimately held to be successful. It requires the raising of a good faith dispute, which is different. contractual language deliberately focuses on good faith. Since the judge held that Sisskill honestly believed it was entitled to withhold payment of the AG5 invoices, that is, in our submission, sufficient. It doesn't matter that the judge held that Mr. Summerfield's belief was incorrect. And in our submission, the judge was right on this issue. Leaving aside its other complaints, IBM appears to accept that if Mr. Summerfield, acting in good faith, had simply instructed Miss Clough to dispute the invoice on the ground of delay, and she'd gone on to do so, leaving no room for the prevention principle, then on the judge's findings, Sisskill would have disputed the invoice in good faith. And in our submission, there isn't a material distinction between that situation and the facts as they transpired. And finally, it's worth interposing here that Mr. Summerfield's error was more formal than substantive for these reasons. Because on the judge's findings, on damages for delay, Sisskill was entitled to set off against the AG5 invoice its damages for delay, which were far in excess of the £2.9 million invoice. That's judgment, paragraph 338. So, while Sisskill wasn't entitled to rely on IBM's delay to withhold approval of a purchase order, it was entitled to rely on it to refuse to pay the valid invoice that IBM ought to have been able to render. Sisskill only failed to establish that IBM's purported termination was a repudiation on that additional ground, because the judge held that a set-off had to be relied on within 7 days of the invoice. That's judgment paragraph 356. And IBM accepted that Sisskill was in principle entitled to set off any damages claim, but only relied on the 7-day limitation point in this context. That's judgment paragraph 332. So Sisskill's challenge to that part of the judge's conclusion only arises if IBM succeeds on the dispute in good faith point, and that is the subject. This is the subject of the next issue, issue 3, as identified. I don't know whether that is a convenient moment.
Yes, so that brings you to your third heading.
Indeed.
Yeah. No, that's fine. Thank you very much. We'll come back at 2 o'clock. Thank you very much.